Good afternoon to everyone. Bon après-midi. This is Nalini with the Law Society. I'm sitting here in the boardroom with my colleagues and with Judith Hall. I'm very excited that Judith Hall, who is passing by Hikaluit, will be able to deliver this CLE today. And as I understand it, this is kind of a baseline CLE, and Judith has kindly offered to continue on with this topic with a deeper dive with a series that Judith will be offering to the membership. I also wanted to mention that Judith will be sharing her PowerPoint, so we'll make sure to post it on the website later. And before turning it over to Rebecca, who's our CLE program manager, I thought I'd invite Judith to share a bit of few words about yourself.
Oh gosh, hi. So my name's Judith Hall, as Nalini has indicated. I am actually from Port Stanley, Ontario, so I live on the north shore of Lake Erie. To get a kind of bearing, that's halfway between Toronto and Detroit. Lived there for a number of years. I've always lived in Ontario, but I started practicing up here, got called to the bar up here in 2018, right before the pandemic shut everything down. So I can't believe it's almost been 7 years. I'm currently transitioning my practice. I've been a litigator for almost 30 years, so I'm transitioning my practice into alternative dispute resolution and mediation. So that's kind of where this starts. And as Nalini said, I am developing a CLE program that I believe is going to be 6 separate CLEs to do a deeper dive into mediation, conflict resolution, and ethics surrounding those issues, trauma-informed mediation, etc. So
Perfect.
Stay tuned.
Thank you, Judith. It's really great to have you in the boardroom today. And over to you, Rebecca.
Yes, well, thank you, Judith, for, and Nalini for making my job very easy this morning. I did want to flag, though, that Judith has mentioned she's always been in Ontario, but she actually has quite a bit of experience in coming up to Nunavut and visiting communities. And one of the things that's important, and I'm sure we will no doubt talk about in your series, is the fact that mediation can be done across jurisdictions. And that's one of the, the really great things about it. So wonderful to have you here. Great to see everyone. And I won't take up more of your time except to say that recordings of the sessions will be posted online afterwards. And people, if they're able to make the sessions, that's great. But they can diarize to look for the recordings as well.
Thanks, Rebecca. Thanks very much. So we'll start our PowerPoint here. This is mediation with integrity, so we can also consider it conflict resolution as well. It really is an entry-level presentation. So for those of you who've been practicing for more than 10 years, I hope this doesn't put you to sleep. Maybe you can answer some emails at the same time while you're getting CLE credits. So Santana, can you switch to the first main or the next slide, please? So some of the learning objectives today, we want to talk about what the mediator's role is in litigation, or what the mediation role is in litigation. Talk about key preparation steps, develop strategies to manage clients and also counsel, and the use of mediation to advance case outcomes. So we're going to touch on those 4 things. And also, if there are questions from those who are watching, or for those in the room, if you have them, please feel free to jump in and ask. I always find it's better to process those questions rather than wait till the end. So if we can move on to the next slide, please. So mediation is a voluntary, confidential, and party-centered process. The importance is that, first of all, it's voluntary. So both sides to any dispute have to agree to come to a mediation. Now, oddly enough, in some jurisdictions, certainly in Ontario, we have mandatory mediation in certain centers, including Ottawa. And I know I've got some people here from Ottawa in the room, which kind of shifts that from voluntary to mandatory. And you think, well, how does that work? But people can be forced to go to the table, but if they're not actually there on a voluntary basis, it's less likely to be successful. The mediator is actually a neutral party. They're not there to make decisions. They're not there to give counsel to either of the parties. They're there to keep the conversation flowing towards resolution. And resolution isn't the only thing that can come through a mediation. You can also narrow issues. So a good mediation isn't just getting it done and dusted and that one's off the books, but it can also be a place where you sit down, you talk about all of the issues that are plaguing whatever it is, whether it's litigation, whether it's a family situation, and you try to come to some kind of understanding about some of the issues. You can narrow it down. For example, if it were a family matter, there could be property, disposition, child support, custody, all of those things. Perhaps a mediation resolves some of those issues and narrows the disputes on other issues. And that would be a successful outcome, to try to get to that point where those issues are narrowed. Counsel, on the other hand, are there to advise their clients. As you well know, I'm talking to a room full of lawyers, or a Zoom meeting full of lawyers. So I know that you understand that, but there is a difference, because sometimes people think that mediators are going to help them help their clients. They are, but not from a legal advice perspective. They can pressure test the case. So if I'm in a room with one side, I can pressure test with counsel and their client what their position is. Likewise, I can do the same thing in the other room, and it helps them to think about their case, but it's not to give legal advice. So in a mediation, there are different stages. And this is a typical mediation. There's many ways to do this, but a typical mediation, you start with a joint session where all the parties come, I'm going to say to the table, but many are being done virtually now. So you would have the mediator, counsel, parties present. Quite often in those sessions, there's opening statements. So the mediator would give an opening statement about what the mediator's role is, what we hope to achieve in the mediation. Counsel would then each give a presentation on behalf of their clients about their case. And there's always an opportunity for their clients to speak as well. That is usually something that would be done in the client preparation session beforehand, to determine whether or not you want your client to say anything. From the joint session, then the parties tend to go into caucus. So you've got counsel and party in one room, counsel and party in another room. And again, I'm using room sort of in a very loose term, because it could be in person, it could be virtual. And that's when the negotiation then starts, and a lot of it is a back and forth. So that is a sort of a traditional mediation that we'll see certainly in litigation matters. Often, though, we can have a mediation where the parties stay at the table and they start speaking to each other. So that's more of an interest-based mediation. In those situations, we would have maybe a whiteboard where we talk about what are the issues we want to resolve, and we give parties time to talk to each other. So there's many different ways to make this happen. It just really depends on what is the best way forward for the clients. Now, in my practice, I do offer a pre-mediation session where I speak to each counsel to try to determine what the best way forward is. As I said, in litigation, usually it's not that kind of interest-based mediation where the parties stay at the table. Usually we go into caucus and the negotiation starts at that point. And then sometimes the parties will get back together to discuss points. Sometimes they don't. But if at the end, they always get back together anyways, just to recap where we are there minutes of settlement? Did we get it settled? What issues remain? And we'll come back together at that point. So this is very different, of course, than arbitration or court proceedings where there's a hearing, evidence is led, and there's a decision. Mediation is not that, not even close. If we can move to the next slide, please. And as I said, if anybody wants to jump in with questions, please do. So for preparation, first of all, case readiness. You've got to assess whether or not your case is ready for mediation. In litigation, do you have everything that you need in order to be able to advance your case? Are there pleadings? Are they ready? Are they done? Have they been served? Are there any amendments that are needed? It's a terrible thing in a litigation case to go into a mediation where you have, say, pled a case for, say, $50,000, but after learning from all the information that you've gathered and all the evidence that you've gathered that it's actually worth $250,000, don't go into a mediation with a pleading that says 50. Amend your pleadings before you go in, or else that's going to be a hard stop right there. Have there been, discoveries? Do you need expert reports? Has there been full disclosure if this were a family file? Do you have all the evidence that you need in order to be able to properly assess your case? Now, certainly early mediation is always a good option. In some cases, there may be very clear issues that can be defined that dragging something through a case, like a long process all the way to the court doorstep, might not be the most advantageous if you know what the issues are, if they were crystallized early. But again, make sure you have all the key documents, medical, financial, whatever it is that you need to prove your case, make sure you have that available so that you can reference it, so that you can properly assess the case and then determine whether it is ready for mediation. And you also want to balance the litigation privilege and settlement privilege. So you want to talk to your clients about, we've got this information, it's say litigation privilege, so I don't need to disclose it. I'll give you an example in a civil case where you may have obtained an expert report, or you may have retained an expert who said, I can't actually give you a supportive report. You're going to want to share that with your client. It's going to be litigation privilege, provided you don't disclose who that expert is. And you're going to want to talk to them and say, look, we've tried to get expert evidence to help your case, but this expert can't help. So that's a risk. We need to make sure that we factor that into our assessment as we move forward. You can move on to the next slide, please. This is a big one. Client readiness. I think this is where most of the preparation should be done. To be honest, you can prepare your case like there's no tomorrow. And I think lawyers are very good at preparing their cases for mediation. And I think that one thing that often gets overlooked is just how much time it takes to prepare a client for mediation. They're not giving evidence in a mediation. They may be speaking to the other side directly, depending on the situation. But they're going to be giving instructions. So you really need to have them ready to be able to do that and fully informed. And that means there could be a lot of issues that get in the way of getting instructions. If it is a situation where there is, I'm going to say party imbalance. So there's always going to be almost always a power imbalance somewhere in matters, whether it's civil, whether it's family. You're going to want to deal with that issue. You're going to want to deal with the emotions. You are really going to have to prepare them for compromise and what that might look like, and also those emotional aspects. And so every case, when you've got human beings at the table and not just a couple of corporations, so leaving aside any corporate, litigation, two sides where it's corporate, but when you have human beings sitting at the table and it's personal, there's always going to be emotional aspects to it. And building in time for those things to come to the surface, even during a mediation, is important. Many parties will often feel that they can just, I'm fine, I'll be fine, it's no problem, I just need to get this over with. And yet when they're at the table and it's all sitting in front of them, it becomes a very, very different story. So having those very honest conversations ahead of time so that they are prepared that it could be very emotional for them. I've seen, if I had $1 for every time I'd seen it, I'd probably be retired. But so many people who think that they're going to be fine are not fine, and they do have really difficult emotional breaks during these mediations. So you need to build in time for the human element to come bubbling to the surface. I will always explain the mediation process to the client, but I think that's the easiest part. I think building in that time for self-care is really, really important. And sometimes what I will do as a mediator is I will recommend to counsel when they're booking a mediation, particularly if they feel there is a vulnerable client involved, that we build in a second half day, just so that the person doesn't feel pressured into making a decision. Because if there is that kind of pressure, if there is that kind of fear of, if we don't get it done by 5 o'clock, the whole thing's going to fall apart. I think if you can take that away in a meaningful manner, that helps. So if say we've got a plaintiff who is or, you know, a family member in a family law matter who is feeling particularly vulnerable, is afraid they're going to lose their kids or something like that, give them that extra half day so that they not only know that they don't have to make that decision by the end of the day, but that there's this extra bit of time, maybe a week later, so they can just have that breathing room. And I find that often knowing that there's that extra time, they don't actually need the extra time, but it just builds in that piece of safety for them so that they don't feel terrified, like, oh my God, the clock is ticking. I'm not there yet. What am I going to do? Instead, they go, you know what? I can come back next Wednesday and we can finish this and I'll have time to think about it when I go home. But usually then they'll find, okay, I'm good. I want to get this done today. So, but it takes that element of pressure that just isn't necessary to be there. Now, managing expectations is a big one, and you'll see these words BATNA and WATNA. They're not my words. These, I'm going to do a little spiel about what this means, and anybody who's read Getting to Yes knows what it is. Every case has an alternative to settlement. So if the parties don't reach an agreement, the alternative is the courtroom. So BATNA and WATNA are simply the disciplined way that we name the alternative and what it actually looks like. So the best and the worst version of walking away. So BATNA is your best alternative to a negotiated agreement. If there's no settlement, the most realistic, favorable outcome at trial. What is that? Not the fantasy verdict, the realistic one. And then WATNA is your worst alternative to a negotiated agreement. So the downside of the case. An adverse finding, an unsympathetic result, witness who doesn't hold up. All of those things need to be pressure tested. So everything between those 2 points is where there is a zone of risk, and that's where settlement lives, is in that area. So this is what we do in case assessment, is we look at all of that range of outcome, but it's important to talk to your client about that. And because that is usually a lot of information, one meeting with your client to prepare for that is not really a good idea because you're just going to overload them. So you want them familiar with all of this. You want them familiar with the range of possible outcomes. So many people, and I'm pretty sure I'm preaching to the choir here, have heard a client say, well, my friend got thus and so, or when so-and-so down the street went to court, this is the outcome. So, you know, we're the same, or everybody gets free advice from a taxi driver. So it's about managing what are realistic expectations as opposed to what everybody thinks their neighbor got or what they think the outcome should be. You've got to take all of the evidence that's on the case and pressure test it. And I know everybody knows that, but walking it through with a client is an entirely different matter that takes a lot of time so that they are familiar with that. And so that when it comes time to sit down and have those negotiations, they're familiar with the things that the other side may be lobbing across the table saying, well, you know, your witness isn't actually going to hold up because X, Y, and Z, or, well, our expert says this and your expert says that. So that's not really going to look good in front of the court, etc. So, by looking at both the BATNA and the WATNA, you are really pressure testing your case throughout. If you don't look at where the gaps are between that, that's where it becomes difficult to settle. You really have to take a look at that. There's actually, I was at the, I can't remember, it's the ADRIC conference in Vancouver last year. And there's actually a software product now where you can feed everything and it gives you percentages. I don't know how anybody takes that into a math program, but it can actually take you down to what is actually your zone of settlement, and it reduces it to percentages based on the different risks. I haven't tried it. I think it's very interesting, but I also think it may be something to complicate things by starting to feed it into an algorithm, but apparently that's a new thing. So when we talk about alternatives to settlement, you know, there's a number of issues that come into play, not just what's a bad outcome at a trial, but there are also the things like the cost of a trial and then getting to a trial. And I'm pretty sure there's delays up here in the court system. I know in Ontario, it's been a nightmare, and COVID took what was bad and just made it 10 times worse. And I know that everybody's trying their best to make it better. And now, of course, in Ontario, everybody's tinkering around with the rules of civil procedure because maybe that'll make it better. I just think that's going to make it worse. But, you know, the fact that it's hard to get to a trial is a real issue. So those are things as well. It's not just, you know, what are the merits of the case, but also what are the practical realities of being in this type of situation. So, you know, a plaintiff, for example, or one of the parties in a family matter, their worst alternative to a negotiated agreement is not just an adverse finding, but it's also the delay, the expense, the toll of a contested trial. Also in a community, as we know, we just came back from Cambridge Bay from last week, in a community where everyone still knows each other and they'll see each other on Monday. So, you know, what may feel like something very private can often be very public, particularly once it goes to trial. And as we know, trials are public. So those are some of the practical realities that we can talk about as well. Again, I think, and I posted something about this on LinkedIn about 2 weeks ago, what ought not to happen at a mediation table is have one side pointing to the other side going, you know, for us, it's just a business decision and we'll drag you through this whole litigation forever and it's going to be terrible for you, because that's just going to put the person on their back heels. They're going to be like, well, you know, and then they're going to feel pressured. So trying to get all of those things out, but without pointing to one party or the other, just saying, these are the realities of the situation. Okay, we'll clear the table of the realities of those situations. Now let's pressure test our own cases and make it more personal. Now, I somewhat dismissed the corporate side of things. If you have two small businesses in a dispute, it's equally as personal as a family matter or as a as you know, a personal injury litigation, for example. So when you have small businesses, again, if they can't move their business forward because they're stuck in litigation, getting to mediation to help get these problems resolved is critical. So it is equally personal, I think, for small businesses. When you're dealing with big oil companies and stuff, maybe not so much. I'd love someone to tell me I'm wrong, but that may be personal too. I haven't experienced that, but certainly anything with a small business is much more personal. So coming back to this BATNA and WATNA, a good conversation about that. It doesn't move people towards your number, it moves them toward their own number. So it's about thinking about all those sides. It's when both sides price the true cost of their alternative, not just the verdict, but the road to it. The gap between them tends to narrow on its own, and that's where the settlement starts to come in, or at least a lot of resolution on many issues. So that's where you want to ensure client understands risks and the options. They're well prepared for it, well in advance, not the morning of or the day before, but you've got to give them this information and have time for them to process it and ask the right questions. If we could move on to the next slide, please. So written materials. Not necessarily every mediation has written materials, but those that do, they're important. Certainly there are mediation briefs that would set out facts if there's a liability situation, if there are damages, those are important. And again, this is for the mediator to help them, but it's also for the other side. So you're doing your written advocacy ahead of time so the other side can see what your case is. I'm a big believer in getting rid of all adverbs out of every every written document. So don't say they're extremely hurt, because that's just overstating something. Just keep it to the point, keep the evidence, do really good advocacy on paper, obviously, but don't gild the lily. I think always a persuasive tone is the way to go, not adversarial. I know counsel I've dealt with for years and years who to this day do wonderful things like bold and underline and highlight, like they're yelling at you on the page. And that just, I won't even read those at this point. I just like file it. Not interested, don't want to read what you have to say. Either you're here to negotiate and, you know, come to the table and try to resolve things together, or, you know, if you're going to yell at me across the table and starting with that on paper, I'm not interested. Another thing too is to decide whether or not exchanging briefs makes any difference. I find that it can be very helpful because it does help the other side understand what your position is, where you feel the strengths of your case are. I also think that it's a very good idea to acknowledge where there may be some warts along the way, some hiccups along the way. You may want to acknowledge that, because I think that also is a way to, extend a hand across the table to say, we're here to try to get this done, rather than just posturing. Posturing, I don't think gets anybody anywhere in a mediation. And again, a mediation is a without prejudice. It's without prejudice. So if you put in your mediation brief that for the purposes of mediation, we're prepared to acknowledge X, Y, and Z, that's without prejudice. That doesn't have to come back and haunt you. That's not going to come back and haunt you. They can't use that outside of the mediation room. So if you really are interested in trying to resolve either the entire matter or some of the issues, extending that across the table usually helps to move the matters forward, especially if you've done that ahead of time, because it signals to the other side, look, we're prepared to acknowledge where some of the risks are in our case, and we're here to talk about this from a very meaningful and genuine place. And again, when doing briefs, focus on the key evidence, avoid overloading. You don't need a 30-page brief. Nobody's going to read it. They're going to get bogged down in the details. So keep it precise and clean. We can move on to the next one, please, Santana. Thanks. So again, negotiation strategy, identify interest in versus the position. So you want to identify what is important here that needs to get done. Obviously, you're taking a position on matters, but I think it's more important in mediation that you move off positioning into more of a conciliatory attempt to try to get as many issues resolved as possible. You can also explore creative and non-monetary solutions without using too many Ontario examples. We often talk about damage assessments in civil that you wouldn't be able to get in court. I'm not going to bog everybody down on what that actually looks like, because it's complicated, and that would take me like a day and a half just to explain the Ontario automobile situation. But you can explore damage options that wouldn't actually occur in a trial because of things like collaterals and all this other nonsense that you have to deal with. So you can explore things that might not actually fit in all four corners of what a trial outcome would look like. Other things we've done is brackets and ranges. So for example, if you're talking monetarily now, you've got, say one party's, their bottom line is $150,000 and the other party's bottom line or their top number is $50,000, and you've got this $100,000 gap. How do you get there? We've often done blind offers where you put in a range. And so one side would say to me, my range is this. The other side would say, my range is this. And they agree ahead of time that if the ranges overlap, that's where the settlement's going to come. But they have to trust the process. So that's usually an end of day kind of negotiation. I don't know why my computer's bipping at me here. So the other thing too is you want to make sure that the parties that are at the table have settlement authority. There's nothing worse than getting to a mediation and then the person who's at the table only has minimal authority, and that they have to, start making phone calls to get any more authority. Make sure they have authority. If there are limits to that authority, find out what that is and get that on the table right away so that everybody knows what they're dealing with that day. We can move on to the next one, and I'm just going to look up and see if there's any questions. I don't think there's any hands up. So all right, so on the day of things to think about, because what time are we starting, how long is this going, do we need technology, is everybody available, do we need an interpreter? So you want to make sure you have all of that available ahead of time. You want to make sure that there's professionalism, I would say throughout the day, obviously, but in joint sessions as well as when there's any kind of communications between counsel. You want to work with the mediator, whether you're in a joint session or in a caucus. And you want to figure out how to handle the difficult dynamics, but you want to keep that client engaged throughout. And as I said earlier, when you've got a situation where the emotions are going to start percolating up to the top, you want to make sure that you've built in the time to allow that to happen. I will always signal to the other side. I think that we're gonna need some time. When I've dealt with fatality cases, need a lot of time, because even though people want to get things done, you know, it's bringing all that stuff back up to the surface, and they're going to need some time just to deal with it, because when you're dealing with a settlement and a damages case on a fatality, suddenly we're putting dollars to someone's life, and people don't think about, they think about that, but they don't think about that until it actually comes down to, you know, what's the number on the check, and then it becomes really difficult. So you really need to build in time for those kinds of things without losing the parties. You want the parties to stay present, but you need to give them that time to process that emotion. We can move on to the next one. We're going to be done in no time, so nobody's asking me questions. Settlement and post mediation. So things, if we are lucky to get to a settlement, if we've worked hard, sometimes it can happen quickly. Sometimes people start, you know, miles apart with their negotiations. Sometimes they just come in with what we call their, you know, almost final offer to start. If we're able to get into a settlement, what needs to be done then? And that's actually where a lot of the work happens. And that's when everyone's tired, particularly if it's at the end of the day. So you've been negotiating all day, it's 5 o'clock, everybody's tired, you've been in the same room or on Zoom all day, you know, not moving off screen. And that's when you've got to start drafting minutes of settlement, releases, getting clients to sign. I always get my clients, when I'm as counsel as opposed to the mediator, I always get my clients to sign a settlement direction that's for me, in addition to whatever they have to sign for the other side, whatever, in addition to whatever they have to sign for minutes of settlement. But also I get them to sign something that's for me. They're giving me the instruction to settle this case on their behalf and get that settlement done, and whatever that looks like, I'll include fees and all that stuff. So there's a lot of work that comes at the end, because it often feels like there's a lot of sitting around during mediation when the mediator's in caucus with the other side, get some downtime, and then all of a sudden, boom, 5 o'clock and everything starts happening. So that's when you really have to, I would suggest having a second set of eyes. I've always, when I'm counsel, I've always got someone else there with me, not just the client, but an assistant, a student, someone else that can help double check everything that I'm doing. You know, make sure we haven't missed anything, making sure all the numbers add up, etc. So there'll be drafting of minutes of settlement. Quite often the mediator will do that with input from both parties, and then share it with the parties so that it can be reviewed and modified if needed before it's signed. You know, ensure that the minutes of settlement, that the settlement is enforceable. So again, it's making sure, if you know your client is the one offering the money, making sure that they're actually going to be able to do that. And sometimes that means, if it's an insurance company, they're writing a check. If it is an individual, are they going to need time for payment? Do they need a payment plan? All those details need to go into those minutes of settlement to make sure that the settlement is binding. If there's no settlement, what happens next? Well, you can follow up. So a good mediator will actually follow up with the parties, particularly if there's been progress made. Even if that means you're not quite at a number, if we're talking about dollars, get towards that number, you're getting close. Maybe there's a few things that still need to happen. Maybe documentation is needed to help support a settlement. But follow up, the mediator should follow up and say, look, how can I help the parties get, you know, bridge this final gap? Or in a situation where, said, as I indicated earlier, where there are vulnerable clients, maybe there's that next, you know, locked half day, maybe a week later, where they can come back and try to wrap things up then, if there's been good movement, but maybe you're not quite there. We can go on to the next one. Thanks. So professionalism and EDI and mediation. So ethical duties, always act in good faith, confidentiality. Mediations are confidential. So they're without prejudice, they're confidential. not just in terms of the lawyers, but the parties need to know that as well. So this day and age with all the social media, make sure they're not posting stuff on social media afterwards about I went to mediation and this is what they offered and blah, blah, blah. Like that's a nightmare. Don't make sure the clients understand that. Civility, always a big topic these days in our profession. Very important to balance advocacy with respect. As I said, don't yell at each other on paper or across the table or finger pointing. I just don't see that that is a good way to try to get to a resolution. Bullying the other side is not the way to get there. It's just not the way to get there. Now, other issues, of course, cultural competency, very important. Accessibility, very important. Power dynamics, very important. All of these things need to be considered. The life that I come from in my litigation world, I was dealing with plaintiffs, individuals who had been harmed, and they were always fighting against another insurance company. In some cases, historic sexual abuse. So you're either dealing with institutions or you're dealing with the personal perpetrators. There's always a power dynamic, so you have to factor those things in and be very sensitive to them, which is why I offer a trauma-informed mediation practice because, as I said, I think that in most cases, you're going to have some level of emotional involvement when there's real human beings at the table. So my goodness, it's like 22 and I'm kind of through my slides. So I don't know if there are questions. This was certainly designed to be more of an interactive, and I feel like all I can talk, but I can't see anybody on the screen. So far away. So does anyone have any questions for me about any of this? As I said, this was a very basic introductory one. So yes, you have a question?
Go ahead, Rebecca. Did you want to? Rebecca, did you want to say something?
Oh yeah, I was just gonna, I was wondering if you wanted to make any further comments on specifically when you're dealing with a region like Nunavut and a lot of things are online, how might that impact some of the general comments that you've said? I know you said a few things about that, but maybe you could say a bit more.
When everything's online?
Yeah.
Yeah, so it's one of the big problems. Well, there's a couple of big problems with everything being online. So if you're online and you're in the same space as your client, I always try to do that if possible. And I realize up here that may not be possible. Because then at least I feel like I control the room that I'm in. But if I am, and I'm speaking now as counsel versus a mediator, if I am not able to be with my client online, so I'm thinking back to the COVID days when, everybody was somewhere else. One of the big problems is engagement. So if your client is starting to shut down, they're just going to go offline. They're just going to go, oh, I'm just going to step away for a minute. You have no idea what's going on. I always try to find out who's in the room with them. Is there any undue influence in the room? Like who else is informing them? Certainly they may have a support person there, but we always ask, as a mediator, I would always ask who else is in the room with you. Going back to maybe the beginning of a mediation, it would be important to know if there is anybody else that's attending virtually, because those people might be witnesses at a trial. So even though there may just be your client on screen, it really is important to know who else is in the room. We would do that in person. You wouldn't just invite your whole family in. I would, as a mediator, I would certainly control that, because it is important for people to have their supports, but it's also important that they are identified, because there can be a lot of influence that's happening. And if you don't know that person's there as counsel, how do you help them when they're getting somebody in the background telling them that it's not enough money and it's not enough this and it's not enough that? Like, it's really difficult to try to manage that piece. Forgive me for the phrase mansplaining, but there was one time many years ago where I had a woman. She was in her 50s and she was my client, and her father and her brother came, and everything I said to her as her counsel, her brother then decided he was going to re-explain it to her. So it was a very long and difficult day, but it was crazy. But that, I mean, that happens. That happens. Or again, you have that person in the back end going, well, you know, Joe down the street got $52,000, not $51,000. So you need to keep going. So there's this pressure that can be there. And if you can't identify it, I think it's really, you know, you've got to be able to understand what's going on. Now, because they're not giving evidence, it's not the same. Like, they can have their notes, they can have whatever, you know, they need around them to make them feel comfortable. But again, it still helps to know if there's any undue influence in the room. I hope that maybe answers some of the questions.
Yeah, because we had Terry who asked what are our thoughts regarding virtual versus in-person mediation, which I think you just touched
Yeah,
on.
I think virtual is great because it allows people to get together without that added burden of coordinating, getting physical bodies in a room, and that can often be a burden. We've certainly noticed a difference doing it virtually because it allows better scheduling, I think, for all the parties. However, there are some cases that really do require in person. I had a couple of parties reach out to me recently where there was a very vulnerable plaintiff, and they said, we really think this needs to be done in person. And then we talked about ways to make that more comfortable for that individual. And one of the things I recommended was that normally you would find a neutral place, like say a court reporter's office or, you know, some boardroom somewhere. But in that instance, because this person was quite young, an adult, but quite young, it had been a horrific sexual abuse situation. We believe that putting them in a boardroom at their own lawyer's office would probably make them feel more comfortable because it was a space they were familiar with, and defense counsel was in agreement with that. So it was actually defense counsel who reached out to me about it. So thinking about things like that. So there are times when in person is better, but you don't want to, what's the word, like hamstring the whole process by just trying to, you know, fit it into an in person if there's too many logistics that are going to get in the way.
Perfect. We have 3 questions.
Okay.
Hi, I have a question. Can you elaborate on how AI could or does affect mediation practice? Does AI usage lead to AI determinations as to what is the optimum objective settlement?
Oh, well, I mean, the settlement shouldn't be impacted by AI, but if clients are using AI to tell them what it should be settled for, that's going to be a problem. But that is that's definitely going to be a management issue ahead of time in terms of prepping your client. I know a lot of counsel now are using AI to feed material like evidence in to get summaries, certainly. In terms of outcomes, again, I think it's just really understanding, you know, in litigation, understanding what other cases have settled for. If you're talking about like non-pecuniary general damages, so pain and suffering damages, understanding what those ranges are and what the court does. I mean, the court's not going to give you an AI outcome. The court's going to give you an outcome based on the things that the court has to assess. So I do think that AI can get in the way with assessing cases if your clients are relying on it. And, you know, again, like listening to Joe, the taxi driver, give you advice is the same as maybe listening to Claude or ChatGPT give you the advice. I think you really need to dial that back. But in terms of AI in the actual process, lawyers may be using AI to summarize some of their information or some of the evidence. I know that there are some, I think Supio is one of them now where it's legal based, so it's not going out into the whole world. So you can actually be apparently comfortable that this is confidential, but I've not used that particular system. We used FileVine, we used FileVine. I don't know what's happening here. We used FileVine in my litigation practice, and they built in some AI that was there. Again, it was helpful for maybe summarizing volumes of records, but otherwise for predicting anything, no, we wouldn't use that. Doesn't mean that it's not going to be there and a bigger problem in the future, but I haven't come across it much yet. Hope that answers the question. It's shaggy dog way of answering the question, but
in a case where trying to get to mediation is causing delays, i.e. discussions about mediation but no commitment, at what point do you decide to pull the plug and file the court application?
Well, watch out for limitation periods. That would be the first that would be the first thing. Certainly I would recommend that, you balance the any limitations that may be there, and as well what the interests might be. I mean, it's a broad question, and I think it's a good one. If you're dealing with family matters, if you've got interests of children that are just being put on the back burner while you're, going around in circles trying to get something scheduled, you want to make sure that the best interests of those children are front and center. So if you're trying to get a mediation, it's not happening, I would suggest that you would want to then at least keep things moving forward so you get the process started. It doesn't mean you can't mediate anywhere in the middle. You could mediate the day before trial for that matter if you need to, but it's obviously better to get it done earlier rather than spending all the time and money getting ready for a trial.
Any comments on cultural considerations before/during mediations?
Oh, obviously, and not just northern communities. I mean, all communities. There's always the cultural considerations that you have to take into effect, and I think that you need to understand those from the beginning of any case. What the cultural implications are in your case, how your client, how your client is going to react to the whole process, what help they might need. There's so many factors that go into it, and I think you have to be alive to all of those factors right from the beginning, not just at mediation. And if you're dealing with it on the other side, I think the other side also needs to be aware. So if you've got, say, an insurance company on one side and an Indigenous person or a racialized person on the other side, I think that those also need to be things that are brought to the fore. And if I were counsel representing that person, I would make sure I would at least address that in my brief so that they knew that those issues were going to be addressed. Any others?
I'm wondering if you could share more about what a trauma-informed mediation looks like compared to a more standard mediation approach. Also, what it could look like within a Nunavut context.
So I think where I approach a trauma-informed mediation. So first of all, you have to acknowledge that there has been the trauma, and you want that you want to ensure that the person who has been harmed is put into a safe place, that their harm has been acknowledged. And that's not just one of those off the cuff, I'm sorry this happened to you, but here we go into the mediation. So it really is about giving them the comfort. So the example I was using earlier about the defense counsel who actually called me and identified that the plaintiff was a vulnerable plaintiff. There had been sexual abuse in her history. That wasn't what the case was about. It wasn't about the sexual abuse, but just that she didn't really have proper supports. They were concerned that they didn't, as the insurance company, didn't want to feel that they were, ganging up on her in any way, and they didn't want to have that sense. There were very difficult liability issues at play in this particular case. And so what the container we crafted for that was that it would be proposed that the mediation be held in person so that the plaintiff could then identify the people. So there hadn't been discoveries yet, but the lawyer really is the lawyer is really the face of a case, not the insurance adjuster, even though that's the person making the decisions for any insurance company. So the lawyer is the face. So in getting to know them, being in the same room together to have those conversations, we decided that it would probably be best if it were at the plaintiff's lawyer's office so that she was more comfortable with that space. She'd been there before, she would know that space. And then building in the second day so that there would be no sense of pressure on her for decision making, and to build in the time that would be needed so that, because there would be, in situations like that, there can be a lot of shutdown, like just can't cope, don't want to make a decision in this kind of, distancing and, just pushing away from the whole process. So building in those kinds of things to help the process through and to help that person feel comfortable in the decision making. And I think that would be the same here if there's a particularly traumatic situation where someone needs the time, whether this is again a family situation or some other situation in the community that needs to be resolved, building in that time for the individuals involved to process what's going on, to ask the questions that they need answered, and to give them time to make the decision, acknowledging the difficulties that have been experienced. And again, that's something where I would, as mediator, and I know other mediators do this as well, we would have a pre-mediation session with counsel to figure out what the best container for that mediation might look like. And it could be, a day plus a half day. It could be a series. So you're getting together just to talk about certain issues. When we were in Cambridge Bay last week, we went to to CHARS, the Canadian High Arctic Research Station, and they have this wonderful room in the center where everyone can speak and no one is louder than the other person because of the way the acoustics were. And I think that was like a container like that would be such a wonderful place, as opposed to sitting at a boardroom where there's sides, having something circular. That's another way. There's so many ways to configure how you would do a mediation to help people feel that they are not on a side, but as part of a process to try to get something resolved.
There's no additional questions.
Okay. All right. Well, if there's no other questions, I think that wraps it up. I want to thank everyone for attending and for all your questions. And
thank you.
thanks. And yes, Nalini said that we would be posting the slides. And as I said, there's going to be a few more. I'm just going to be working on the development of those over this summer. A little more detailed from this, and hoping to come up and do some mediations for everyone if you need them. Maybe we talk to folks later about that over the next couple of days while I'm here.
Perfect. Thank you so much, Judith.
Thank you.
As Rebecca mentioned at the beginning, there is additional CLE posted on the Law Society website, so feel free to check those out if you need your hours. Thank you again.
Thank you. Have a great day, everyone.